Welcome to the Deep Dive. Today we're tackling a really important concept, negligent misrepresentation.
Yeah, it comes up a lot, especially if you're, renting a place or dealing with real estate here in California.
Exactly. That feeling when someone tells you something, it turns out false, and suddenly you're out of pocket. That's often where this whole idea clicks in.
It's about those times someone makes a statement that isn't true. Maybe they thought it was true, but, well, they didn't really have a good reason, a solid basis for believing it.
And that's crucial, right? Especially for tenants. We see this affecting renters quite a bit.
Definitely, and it can have real legal consequences here in California.
So that's what we want to dig into today. What does negligent misrepresentation actually mean under California law? We'll look at, the definition, what elements you need to prove.
How it's different from, say, outright fraud.
Right, the intentional stuff. And, crucially, why this matters so much if you're a tenant or renter dealing with property issues. And folks can always find more on topics like this at martinezlawcenter.com.
Good point.
Okay, so let's start right there. How does California law define this? What is negligent misrepresentation, legally speaking?
Well, the law gives us a couple of key definitions. One is in the Civil Code, Section 1710. It basically says it's asserting something as fact when it's not true, and the person saying it has no reasonable grounds for believing it's true.
No reasonable grounds. So it's not just being wrong later, it's about whether they had a good reason to think they were right at the time they said it.
Precisely. Like you said, did they have a solid basis? Or were they just guessing, or maybe being careless?
Got it.
And there's another similar idea in a different part of the Civil Code, Section 1572. It talks about a positive assertion, so stating something quite firmly in a way that isn't warranted by the information they actually have, even if they believe it's true. Again, the focus is, did they have enough info? Did they do their homework?
So, okay, we have these legal definitions, but say I'm a tenant and I feel like my landlord told me something misleading. What are the actual hoops I need to jump through? What do I need to prove in court?
Right. So there are several key ingredients, elements you need to establish for a claim in California.
Okay.
First, and this is fundamental, you need a false representation of a material fact.
Material fact, meaning like an important detail, something that would actually affect my decision.
Exactly, something significant. And it has to be about something, past or present, a fact that exists now or did exist, not just guessing about the future.
So if my landlord says, oh, property values here are definitely going to skyrocket next year, that probably doesn't count.
Generally, no. That sounds like an opinion or a prediction. Future stuff is usually out unless maybe the person has some super specialized knowledge making their prediction almost like a statement of fact. But usually we're talking concrete details.
What about like this place has great vibes or it's a wonderful neighborhood? Is that a representation of fact?
Usually not. That's typically seen as puffery, sales talk, subjective opinion.
Okay.
It becomes a material fact if they say something specific, like the heating system was replaced last year, and it turns out it's actually 20 years old and failing. That's specific, verifiable.
That makes sense. So first element, false statement, important fact, past or present. What's next?
Second, and this is really the core of the negligence part, lack of reasonable grounds for belief.
Okay.
The person who made the false statement, they didn't have good, solid reasons to believe it was true when they said it.
Even if they genuinely thought it was true, like they really believed it.
Even then, honest belief isn't a shield if that belief wasn't reasonable. Did they check? Did they ignore warning signs? Did they have any basis for saying it?
So if a landlord tells me, yeah, the roof is fine, but they've never actually looked at it, or maybe they even got a report saying it needs repairs, that could be it.
That's exactly the kind of scenario. They might think it's fine or hope it's fine, but they lack reasonable grounds for asserting it as fact. There's a level of responsibility there.
Okay, so false statement, no reasonable grounds. What's the third element? Something about intent.
Yeah, intent to induce reliance. Now this one, it gets a little nuanced in California law sometimes.
How so?
Generally, it means the person making the statement intended for you, the listener, often the tenant, to rely on that statement. Like they wanted you to believe it to make your decision, maybe sign the lease.
Okay, they wanted me to act based on what they said.
Right. But some interpretations, and even the standard jury instructions, suggest that for negligent misrepresentation, unlike intentional fraud, proving that specific intent might not be strictly necessary.
Oh, interesting.
Yeah, the focus might lean more towards whether it was foreseeable that you would reply.
So Less about them trying to trick me, and more about them being careless with facts they knew I'd likely rely on.
Exactly. It shifts the focus slightly from active deception to irresponsible communication in a situation where reliance is expected.
Got it. That's a key distinction. Okay, element 4.
Reasonable reliance. This means you actually did rely on the false statement.
Okay, I believed it and acted on it.
And crucially, that your reliance was reasonable. Would an ordinary person, someone with common sense in your shoes, have believed it and acted on it?
So if someone tells me the apartment comes with a free unicorn, and I sign the lease based on that, probably not reasonable reliance.
Chuckles slightly. Probably not, no. The law expects a certain level of common sense. Context matters. Who said it matters. You'd reasonably rely more on a landlord's factual claim about the plumbing than, say, a wild boast.
Right. Okay, that makes sense. And the last piece. There has to be harm, right?
Yes, causation and damages. You have to show that your reasonable reliance on that false statement was a significant factor in causing you actual harm.
Usually financial harm.
Most often, yes. Financial losses. Maybe you had to pay for repairs they said weren't needed, or perhaps you incurred costs because an amenity they promised wasn't there. There needs to be a direct link. The false statement led to reliance, which led to quantifiable damages.
Okay, so let's recap those elements quickly. 1, false statement of a material fact. 2, the speaker lacked reasonable grounds to believe it was true. 3, intent to induce reliance, or maybe just foreseeable reliance. 4, your reliance was reasonable. And 5, that reliance caused you actual harm or damages.
That's a great summary. Those are the key hurdles.
Now, we touched on this, but let's really hammer home the difference between this negligent misrepresentation and intentional misrepresentation, or fraud. It seems to boil down to the person's mindset.
Absolutely. It's all about what was going on in their head. With fraud, the person knows the statement is false, or they're acting recklessly, like completely disregarding whether it's true or false.
They intend to deceive.
Yes. There's deliberate intent to mislead you, usually to get something from you. They're actively trying to pull a fast one, as you said.
Okay. And negligent misrepresentation.
Negligent misrepresentation is different. The person believes the statement is true, but as we established, they don't have reasonable grounds for that belief.
They were careless. Didn't do their due diligence.
Exactly. It's about being irresponsible with the facts in a situation where accuracy matters. They weren't necessarily trying to lie, but they failed in their responsibility to ensure what they were saying was reasonably accurate. It's carelessness versus deliberate deception.
That distinction feels really important for tenants navigating issues. Okay, let's make this really practical. Can you give some real-world examples of how this might play out for a renter in California?
Sure. Let's think about common tenant issues. Imagine you're looking at an apartment. You ask the landlord, has there ever been a bed bug problem here? They say, nope, never. But maybe they know the previous tenant had a huge issue and they just had a quick spray done without confirming the problem was fully gone. They might hope it's gone, but they don't have reasonable grounds to say never.
Right.
You rely on that, sign the lease, move in, and boom, bed bugs. That could be negligent misrepresentation. They made a false statement about a material fact, past history, lacked reasonable grounds for the assurance. You reasonably relied on it, and now you have damages, treatment costs, maybe ruined furniture, stress.
Ugh. Yeah, that's a nightmare scenario. What's another one?
How about safety? Say you ask about the security in the building, maybe about recent break-ins. The manager says, oh, it's super secure, we've never had a problem, when actually they know there were several car break-ins in the garage recently, but they haven't upgraded security yet.
So they're downplaying a known issue.
Right. They don't have reasonable grounds for claiming never had a problem. If you rely on that feeling of security, move in, and then your car gets broken into because of the known unaddressed security lapse, that could potentially be linked back to their negligent misrepresentation.
It's about those specific factual assurances that turn out to be carelessly false.
Exactly. Or think about advertised amenities. They say, newly renovated gym. You sign the lease partly based on that, and find out the equipment is old and broken and renovated meant a coat of paint. If they didn't have reasonable grounds to call it newly renovated in a meaningful way, that's potentially misleading.
These examples really hit home. Now, something called the economic loss doctrine sometimes comes up in legal discussions. You mentioned it briefly. Can you just clarify why it usually doesn't block these kinds of claims for tenants in California?
Sure. The economic loss doctrine, it's a complex area, but basically it tries to keep contract law and tort law, like negligence, separate, especially with defective products. It often says if your only loss is economic, like the product didn't work, costing you money, you should sue under contract law, like warranty. warranty, not tort.
Okay.
In California, courts have generally said this rule does not bar claims for negligent misrepresentation, especially in real estate deals or service contexts like landlord-tenant relationships.
So if a tenant's loss is purely financial, due to relying on a landlord's negligent misstatement, this doctrine probably won't stop their claim.
That's the general consensus in California, yes. Negligent misrepresentation often provides a path for recovery, even for purely economic losses in these situations.
That's really good to know for renters.
Yeah.
Okay, one last crucial point. You mentioned needing specifics. What does pleading with particularity mean for a tenant making this kind of claim?
It means you can't just file a lawsuit saying my landlord misrepresented things. You have to be very specific.
Like, spell it out.
Exactly. Your legal documents need to state what was the exact false statement, who said it, when and where was it said, how was it false, how did you rely on it, and what specific damages did you suffer because of that reliance.
So general complaints won't fly. You need the details documented.
Precisely. The courts require that level of detail for both fraud and negligent misrepresentation claims in California. It helps ensure the claim has a real basis.
So keeping good records, emails, notes from conversations, lease agreements is super important if a tenant thinks this happened to them.
Absolutely critical.
Wow, okay. This has been incredibly helpful in understanding negligent misrepresentation, especially from a tenant's perspective here in California. Let's just quickly summarize the big takeaways.
Sounds good. So negligent misrepresentation in California. It's making a false statement about something important, believing it's true, but lacking reasonable grounds for that belief.
And for tenants, this often relates to things like the property's condition, safety, pests, or amenities.
Right. To win a claim, you've got to show those key elements. The false statement, the lack of reasonable grounds, your reasonable reliance, and the resulting harm, usually financial.
And remember, it's different from intentional fraud. The key is carelessness about the truth, not necessarily an intent to deceive.
Also, that economic loss doctrine usually isn't a roadblock in California for these claims. And finally, remember, you need to be very specific, plead with particularity about the details if you bring a claim.
And, importantly, if you are a tenant, a renter, in Orange County, Riverside, San Diego, or Los Angeles, and you think you might have been harmed by a landlord's negligent misrepresentation, you can find more information and resources at martinezlawcenter.com.
That's right.
It really does make you think, doesn't it? We rely on so many statements and assurances every day, especially when finding a place to live.
Yeah, and when that trust is broken, even through carelessness rather than malice, and it causes real problems, well, that's exactly what negligent misrepresentation addresses. Understanding it is vital for tenants to protect themselves.
Call now 714-442-9741. Thank you.